Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about what documents should you have ready for when you're going to meet with an estate planning attorney. Now, typically when you're going to meet with an attorney, they're going to send you a pre-package that has your basic information. It's going to ask about, your name, your spouse, number of children, number of grandchildren, a general idea of what your assets are. It's going to ask for a general overview in terms of how much equity is in your home, what your investment account looks like, what your IRA or 401k or 403b or TSP account looks like. It's also going to ask about cars, any boats, vacation homes, things of that nature. Now that's the basic information. What you should also set aside or have prepared is more detailed information of where those accounts are. Where are they located? What are the general amounts in those accounts? Estate planning changed significantly because of the 2009 Secure Act, where they affected the way that IRAs can be inherited through the estate plans. We used to be able to what was called stretch out an IRA, which is we could take your IRA, put it into a trust, and stretch it out for years to your children, so that way reduce the amount of the required minimum distributions based upon the age of your oldest child. So you had a small RMD, which allowed the IRA to explode in value over the years and basically became your kids' retirement funds. That's changed significantly. Now that has to be paid out over a shorter, more specific time period. And it's not quite as effective as it used to be. One of the other things you want to have is you want to have the actual physical addresses of any vacation homes that you have. This can be vitally important, especially when you're talking about out-of-state vacation homes. So here in Virginia, it's very popular for people to have a vacation home either at Bethany Beach, Rehoboth Beach, or down at the Outer Banks, down in Duck, or Nags Head, even Corova. It's one of those, if it's an out-of-state vacation home, then you definitely want to put that property into a trust, because by placing that property in a trust, you avoid having to have a second probate. Otherwise, not only do you have to open up probate here in Virginia when you pass away because you're a resident of Virginia, you're also going to need to open up probate or deal with the probate courts in the state where your vacation home is located. So if you have a vacation home at the Outer Banks, then your family's going to have to deal with the probate courts down in North Carolina, which can be a real pain. And sometimes you have to hire a whole nother attorney to handle that. However, if you place that home, if you do a quick claim deed, placing that home in a trust does not trigger any issues with your mortgage company, doesn't accelerate any of the costs or anything like that. There are exemptions for that. But what it does is it places the home in the trust. So when you pass away, the trust is still the owner of the property, which means you don't have to open up the probate in Virginia. You don't have to open up probate in North Carolina or in Maryland. That the vacation home can continue to be owned by the trust and can be there for the benefit of your children. And if they decide to sell that property, then the money goes into the trust and can be distributed to the children that way. It does not require any additional probates or any other matters because it's owned by the trust, and the trust continues to live on even after your passing. Although the trust is going from a revocable trust to an irrevocable trust, that does not have any effect whatsoever on your vacation home that's out of state. One of the other topics that you want to have your information for is insurance policies. Insurance policies can be placed into a trust, so that way it pays into the trust and the trust can pay it out to the beneficiaries. Now, some people might think, why are you making this? That sounds awfully cyclical. The reason why you want to place the money into the trust is the trust has that creditor benefit that if it were paid out to the children outright, they don't have that creditor benefit. They don't necessarily have that protection from divorce either. And it's very common for children to receive inheritance from their parents, commingle those funds with their spouse, and then those funds end up becoming part of a divorce later on or a separation. And it can be really, really difficult for them to try to prove or segment out what money came from their inheritance versus what money was part of the family. What part of the money was part of the family assets. The easy way to avoid all that is just to have the trust be named as the beneficiary, and then the trust will pay out to the children anyways. Should you have any other questions about what documents you should have ready for when you meet with your estate planning attorney, feel free to reach out to the Johnson Law Firm. We typically have a list of documents that you should have ready. We're happy to share that list with you, whether you meet with us or not. Just go to our website or give us a call, and we're happy to provide you with a common list of documents and accounts that we recommend that you have information ready for in terms of meeting with your estate planning attorney.